Good evening. Happy Thursday. There are three issues that I'm going to cover in this particular video. Most of you are going to be here for what's going on in the Decastro versus Abrams et al. Case. So I'm going to cover that first. Then I'm going to cover the debate between me and Jack. And then I'm going to cover the interview that I'm going to do with Lauren DeLaguna, or Lauren Hayden. I don't know why she has two last names. She might be married for all I know. I don't know. So anyway, she has one of those two names. So first, on the Decastro versus Abrams, on the 9th of November, Chili filed, he e-filed it through ECF, I believe, this letter to the judge. I'm writing in response to a correction needed in the docket for this case. On November 6, 2022, at approximately 12:17 p.m. Eastern Time, I e-filed a notice of voluntary dismissal for this case after you indicated it as an alternative to my motion to transfer, and I emailed the notice to all parties the same evening. As of today, my notice of dismissal has not yet appeared in the record. I pray that the court will investigate the missing file and correct its recording so that it may do its housekeeping. It seems that perhaps the defendants thought I was bluffing with my notice of dismissal due to the error of the record, so I would not be opposed to the refund of their filing fees for any answers or cross-complaints, although technically they should be liable for the payment of responses that they filed where they were notified of the dismissal before they served me the filed responses. I have emailed the docket clerk a couple times regarding the missing filing, but they have not been able to find the document. It seemed necessary to notify you to have the court escalate the investigation of the issue to correct the error in its record. Thank you. Now, this has a lot of stupid things in it. The whole thing about the filing fees being refunded, Chile obviously doesn't have any control over that. It doesn't matter whether they thought they could or not. It's just, I don't know why he thought that he had some sort of control over that. He didn't, as a tax attorney pointed out, he did not actually ask for the specific relief that he really wanted, i.e. to have his notice of dismissal entered as of the 6th of November. He asked instead for an investigation, and obviously the judge is not going to do an investigation. That's ludicrous. It's not the judge's job to investigate what went on with Pacer or with Chili's computer or anything like that. And the clerks don't care, and I don't even think the clerks have anything to do with the filing itself. I think it's the person who's filing it that clicks all the right buttons to make the thing happen. My ECF filing is limited to, I think I filed one thing once in ECF, but I couldn't tell you how to do it at this point. But my best understanding, based on what other attorneys have said, is that Chile controlled the whole entire filing. He get to pick what each document looks like. Upon filing it, it's automatically served to opposing parties. So, I mean, he should have known on November 6th that it wasn't filed because he didn't get an email on it. So then that was he filed this on the 9th. That was yesterday. Then today he filed this. Plaintiff's notice of voluntary dismissal without prejudice. I, Jose Decastro, hereby notify the court and all parties of my voluntary dismissal of this action pursuant to Rule 41A1A, subsection I. The defendants have not filed an answer nor a motion for summary judgment, and I have an absolute right to voluntarily dismiss this action without prejudice. This case will be refiled, and the defendants are on notice to protect any relevant evidence. He dated this November 5th, 2022. Now, obviously, this is filed on November 10th, 2022. It's not that the clerk found it in the system. It's that he filed it on November 10th with this date. Now, again, he is a pro se plaintiff. And because he is a pro se plaintiff, it is my experience that the court is going to look for every excuse possible to do what Chile wants, to do what the pro se plaintiff wants, to construe things in a fashion to effectuate what the plaintiff or the pro se litigant really wants. So just because he didn't ask for the correct thing here doesn't necessarily mean that the court's not going to figure out, what he's really looking for is this. Now, whether or not the court grants it is a different story, and to be perfectly honest with you, I would never bet on the court going one way or the other on something like this, because I have been surprised more often than not when the court has not followed the technical letter of the law, where if it says it has to be filed by this date, and it wasn't filed by that date, and the court said, well, you know what, I'm going to allow it to happen, and to make it fair, I'm going to give you a few extra days to prepare your response, to make up for the time that you didn't have because they didn't get their filing in right. So I am as an attorney, my default position is always prepare for the worst. Hope for the best, but prepare for the worst. So I would have been ready to fight it out if the court decided to turn it into a motion to dismiss. So what did the court do? This is the court's order. On October 24th, 2022, the court held a status conference that was attended by all parties to this action. During the hearing, plaintiff requested and was granted leave to electronically file as a pro se litigant. He subsequently made use of the court's electronic filing system and filed on October 31, 2022, a motion for clarification and a motion to transfer. On November 7, 2022, defendant Abrams and Peter each answered plaintiff's complaint and filed counterclaims. So the court is noting that he was able to use ECF on October 31st, 2022, successfully twice. If he hadn't, that might have changed the outcome. The following day, November 8th, 2022, plaintiff sent an email to the clerk. So this one that was that ended up being filed on the 9th, he actually sent it in as an email. He didn't file it, so that's interesting. That's something to note. He sent an email to the clerk of the court in which he claimed he had attempted to file a notice of voluntary dismissal, the notice, on November 6, 2022 at 12:17 p.m., i.e. before the defendants answered. See something attached to his email, a screenshot of his browsing history. He attached to his email a screenshot of his browsing history on Google Chrome, which he described as metadata, as well as a PDF of the notice, which was dated November 2022. Thereafter, on November 9th, 2022, plaintiff electronically filed on the docket. This is stupid. Hold on. It's hard to read this. So we're going to go to I want to go to thank you, TDRE. Where are we at? Why didn't you jump me to it? There we go. All right. I.e. before defendants answered, attached to his email a screenshot of his browsing history on Google Chrome, which he described as metadata, as well as a PDF of the notice, which was dated November 5th, 2022. Thereafter, on November 9th, 2022, plaintiff electronically filed on the docket a letter that reiterated his claim. I guess he did file that one. Perfect. That reiterated his claim that he filed his notice on November 6, 2022, and asked the court to investigate the purported missing file and to, quote, correct the error in its record. The clerk of the court then, on November 10, 2022, entered on the docket the notice that the plaintiff attached to his November 8, 2022 email. Other than the date on the notice, which was sent to the clerk on November 8, 2022, and later entered on November 10, 2022, there is no evidence to suggest that plaintiff drafted the notice or attempted to file it prior to defendants answering his complaint and filing counterclaims. And then it continues on. As discussed, plaintiff was granted leave to file electronically on October 24th, 2022, and successfully did so on October 31, 2022, a week before he allegedly encountered issues with the electronic filing. The court further notes that any technological issues plaintiff encountered on November 6, 2022 appear to have been resolved, as he was able to electronically file a letter on the docket on November 9th, 2022. Plaintiff has also not offered any explanation as to why, if he was unable to file the notice on November 6, 2022, did he not attempt to refile the notice and did not alert the court of his inability to file until 2 days later, and importantly, after the defendants had answered and counterclaimed. In any event, because defendants answered his complaint and counterclaimed, pursuant to Federal Rule of Civil Procedure 41, the court may only dismiss the action with the defendant's agreement. Defendants are therefore ordered to indicate in a written filing whether they consent to dismissal of this action by November 18, 2022. And so I am certain that Mr. Wish and Josh's attorney, whose name I don't know, are going to file a big fat nope on the record on or before November 18th, 2022. Now, considering the attorney's behavior to date, I'm going to guess it's going to be closer to November 18, 2022 than now, but if it was me, I would have that nope on record just as soon as I had talked to my client and got the permission to put the nope on record, because I'm sure that Kate Peter and Josh Abrams don't want to spend the additional time and money to have Chili refile in the Central District of California, where they can spend more money to get their attorneys admitted pro hac vice to appear for this one matter, yada, yada, yada. So good luck. That's the end of it. He doesn't get his dismissal. The next step is, I'm assuming that Chili is going to file an amended complaint. That is what he's said he was going to do. That's what I assume he is going to do. If he doesn't, or maybe even before, at some point the judge is going to set a discovery conference so that they can figure out whatever discovery issues they're going to have and get the ball rolling on dates things are going to be due, etc. So that is that's what's happening in Decastro versus Abrams et al. Now, on to the next subject. The next subject is Jack. Now, I emailed Jack today at 12:34 my time, discussing the format. So I will let you guys know the format. This is the way I intend for it to go. Now, a big caveat is that I think Jack is drunk and he hasn't been responding either in the comments or to the email or anything like that. So I don't know exactly where we're at. So the debate format, it's going to be hosted by Potentially Criminal, and who is an attorney, a licensed practicing attorney. And then Juan Galt and Paul Carroll, who are also attorneys, are going to fill out the tribune. So we're going to have 3 attorneys who are going to act like judges. So he gets to open, Jack will get to open on why I said qualified immunity. I meant judicial immunity. Doesn't apply. A quick caveat, CJ Grisham deleted his initial video. So if you want to see the underlying basis for the factual pattern that Grisham laid out, I did play it in this video. I was commenting over it at the time, and I was explaining why his habeas pistolis brief was not going to, or motion was not going to get him anywhere. So you'll have to ignore me in it, but you can still get the fact pattern from him, because even though he deleted or privated his video, well, I've got it. So he can go piss up a rope. So anyway, I don't care if Jack argues the facts, or excuse me, if he argues the habeas pistolis argument that CJ made, or his new and not necessarily improved 42 USC 1983 argument, or if Jack has his own argument as to why judicial immunity doesn't apply, that would be great. after Jack has done his argument, I'll present my argument. This is basically the way it would work, at least in California courts. The moving party makes their argument, the responding party makes their argument, and then when the responding party is done, then the moving party gets to make a reply. Sometimes the judge will allow it to go back and forth a few more times. I don't think that I need to do it on this time. I don't plan on responding again. So I think that would be enough. I anticipate this will take about a half hour. The judges, i.e. the three attorneys, get to, there's no time limits on any of this, but the judges, the three attorneys get to act like judges. And if they want to break in and ask questions, clarifying questions, things like that, if they want to stop one of the two, in air quotes, attorneys, well, I'm an attorney, Jack is not, but one of the two arguing parties, if they want to stop them from making a redundant argument or repeating themselves or whatever, they get to act like judges. And so they get to control the flow of the, in air quotes, courtroom. So it'll be hosted on Potentially Criminal's channel, so it won't be on my channel. But if Jack wants to stream it on his, that's fine. I don't care. And then, yeah, so I haven't heard back from him. This would technically, hopefully, go forward if Jack responds on Saturday at 4 o'clock Pacific time, which would be 6 o'clock p.m. Texas time. So I hope this works out. That's the tentative arrangement that I have set up. So hopefully I hear back from Jack. Or you know what? If CJ wants to get in and actually argue for either one of the two potential ways that he came up with for getting around judicial immunity, that's fine too. We'll see if three seasoned, experienced, practicing attorneys believe his bullshit or my bullshit. And then finally, the last thing is Lauren DeLaguna, Lauren Hayden. She did reach out to me. She did join my Discord. She was treated horribly. The only experience I've had with Lauren DeLaguna, Lauren Hayden, whatever her name is I saw her on Clash with Bow's stream getting tag teamed by three very angry women who did not like her. And she bowed out of that. I don't see why she would have stayed. She had nothing to gain by it. And then when she joined my server, my Discord server also ganged up on her and treated her like trash. And she bowed out. And apparently, I have it on good authority from the people in my server that they investigated themselves and they did nothing wrong. But I disagree with them. I did not like the way that Lauren was treated. Now, I don't know a damn thing about Lauren. I just know that a lot of people in this community hate her. And so on Friday at 4 p.m., assuming I could figure out StreamYards, I am going to interview Lauren Hayden, Lauren DeLaguna, whatever her name she has. And hopefully, through my non-adversarial approach, you guys will get to see a better picture, a clearer picture, a less distorted, a less tainted picture of who this person is and what her motives are. And that might change your opinion about her. And hopefully we can maybe get a better idea. And if she's a terrible person, well, maybe that'll come through too. If she's not a terrible person, who knows, right? So I will give her a fair chance. I haven't ever watched any of her videos. I'm trying not to get a lot of information about her. I am pressing X to doubt a lot of the negative information that people are trying to give me to taint my opinion of her before I've talked to her. But I expect to interview her on Friday tomorrow around 4 p.m. my time, Pacific. And she asked me if she could interview me. I said, fine, I agreed to it. I mean, turnabout's fair play. So I don't know when that's going to happen. It might happen right afterwards on her channel. I don't know. And if she wants to stream my interview of her, that's fine too. I'm not in this to make money. I'm in this to share information. So that's what I got for you. Thanks for watching. And Have a great weekend if you have Veterans Day off. Thank you to all the veterans who've served. And if you have to work tomorrow, well, thank you for working tomorrow. Have a good evening.